intended to be available to the public. And normally, when the world is the way it should be, we'd be doing this in a courtroom, and anybody at any time could walk into my courtroom and just watch what we're doing. But because we've had issues with Zoom bombing and things like that, obviously we have to password protect access to Zoom for these hearings, but we still have to provide some sort of public access. And so the Chief Judge of the 20th Circuit has asked us to broadcast this on a live stream on YouTube, which is what I'm doing right now. Just to be clear, there's nothing that's going to be recorded. It's just, like I said, it's broadcast live, and as soon as we're done, it's deleted. I just don't want anyone to think that there's any kind of record being made of this. And I just wanted you all to be aware that I am doing the live stream. All right, Mr. Alsonat, it's been 10 minutes. Go ahead and unmute. And Amanda, I'm going to go ahead and address that case real quick now. This is Portfolio Recovery Associates, LLC versus Kernison Alsonat, 20 SC 2990. Sir, the plaintiff has failed to appear for trial today. I confirmed that they did receive notice of today's proceedings.
Can I say something?
You can.
Yes, sir. I have an agreement with them.
Oh.
I start making payment, and I start on November.
Okay.
23rd. I make a down payment for $352.23. And I'm gonna make a payment every month for $35.22. I should finish the payment by September.
Well,
I sent an email to your office.
Yep.
A few days. Yes.
I got that.
Yes.
I wasn't entirely sure what that meant.
Yes.
I'm not entirely sure why the plaintiff did not send me some sort of notice of settlement.
Yes.
All right. Here's what I'm going to do, sir. Thank you for your patience the last 10 minutes.
Thank you.
Amanda, we're going to just put an entry that the trial did not go forward today due to a pending settlement agreement.
Yes, sir.
I will give the plaintiff an opportunity to file their notice of settlement. All right.
Thank you so much.
But thank you for your time today, sir. Have a good day, okay?
Thank you. Thank you, Your Honor. Have a good day.
Take care, sir.
Bye-bye.
All right. So for you, gentlemen, we are going forward to a trial. Is that correct?
Yes, sir.
Yes, sir.
All right. And is it pronounced DeChico or DeCico?
DeCico.
DeCico. Mr. DeCico, let me let you know how a trial works. Because the plaintiff has the burden of proof, and that burden of proof is called the preponderance of the evidence. They get to go first. All right. I'm going to allow Mr. Spreckman to present the evidence and testimony that he wishes to present. Particularly because we're doing this on Zoom, I'm going to ask that if you disagree with anything being represented, that you wait until it's your opportunity to speak before you say so, because if we talk over each other on Zoom, it really does not work. Similarly, Mr. Spreckman, I did get a packet of proposed evidence here. Mr. DeCico, I assume you got a copy of these documents?
I do, yes. And are you referring to the documents I sent you?
I think this came from counsel for the plaintiff. I don't think I received anything from the defense.
Yeah, I mailed to you with return receipt for all of the documents with the evidence that I was providing, all of the emails and things that I had between myself and Town and Country with all of the issues, and from the beginning, the receipts, the letter from the bank, and all of that last 2 weeks ago.
All right, so you sent it out about 2 weeks ago?
Yes, sir, to your office.
Did you get confirmation of receipt?
Let me see here. I have the. I can look real quick online and track the package.
Sure.
And for whatever it's worth, the judge, I did receive I received the documents from Mr. DeCico.
Okay. So I'll check with my assistant, because I don't have a copy in front of me, but I'll double check with her to see if they arrived. While you're looking for
Yeah,
this,
I'm sorry.
no, go ahead. You were saying?
It says here it was delivered Friday 1:15 at 9:35 a.m.
Okay. All right. She may just not have picked up the mail just yet. Let me just take a moment when I'm done doing my introduction, and then I'll make sure I get those documents before we get started. Okay. So anyway, as I was saying, as I go through the documents, if you have an objection to me looking at the document as evidence, sir, you can object individually when these documents are being presented. Okay. An objection is not a disagreement as to what it means, but simply whether or not I'm allowed to even look at it and consider it as evidence. You understand?
Yes.
All right. Once Mr. Spreckman is done questioning his witness, you will have an opportunity to question that witness as well. All right.
Okay.
When he rests his case, you have full opportunity then to present anything you wish at that time, including the documents, which I'm going to make sure I have in my hand before we get started. All right.
Okay.
All right. With that, let me step out for just a moment. Let me see if that packet is here, and then we can get started. Okay. I'll be right back.
Yes, sir.
Yes.
All right. My assistant is going upstairs right now just to double check the mailbox. We can go ahead and get started because if it's there, she'll just bring it in to me as soon as she gets it. Okay. All right. I did have an opportunity to review the complaint, as well as there was a memorandum of law that was filed, and I did have a chance to review that prior to today's hearing. I did not review any of the proposed evidence, for obvious reasons. But with that, Mr. Spreckman?
Yes, thank you, Judge. Would you like an opening or just go straight to testimony?
Your preference.
Okay. I'll just give a little bit of a brief overview of what the case is about. So this case is about the sale of building equipment. In this case, it's windows and associated products. My client, ABC or Town and Country, they're a supplier of building materials. What the court will see is that the goods were ordered and delivered exactly as ordered. And the dispute is as to, Mr. DeSico could get more into what the dispute's about, but I don't think there's any dispute that the goods that were ordered were in fact delivered. And we'll get into the testimony. Okay. So, Mr. Howe, is the court going to swear in? Or
I am, yes.
Okay.
All right. Mr. Howe, I'll ask you to raise your right hand. And Mr. DeSico, if you're going to testify in your case, would you also please raise your right hand?
Sure.
Do you both solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, put your hand down, please.
Thank you, Judge. So, Mr. Howe, can you please state your name for the court?
Oh, hold on. Mr. DeSico? Oh, there you go. He froze for a moment.
Yes, sir.
No, you froze for just a moment. You're back. All right.
Okay.
All right.
So,
go ahead.
Mr. Howe, can you state your name for the court, please?
Marcus Haupt,
Who do you work for?
Town and Country Industries, Fort Myers, Florida, branch number 813.
And does Town and Country go by any other names?
No, sir. We are owned by ABC Supply.
Okay. What's your position?
I am outside salesman.
So, what's the nature of Town and Country or ABC's business?
We provide building materials for lanai enclosures, for homes, windows, doors, things to install those.
So, do you have personal familiarity with the transactions that led to this dispute?
Yes, I am.
Okay. And have you also had a chance to become familiar with the plaintiff's business records regarding this defendant in this action?
Yes, I have.
Okay. So do those records contain any documentation of what the goods were that were sold to the defendant?
The goods that were sold were the PGT picture windows
Okay.
and
Well,
rec tubes.
So do plaintiff's records contain documentation of what was sold?
Yes, we have that.
Okay.
We have all that stuff.
So the documents provided, they're numbered on the bottom right-hand corner,
Correct.
so everyone can see. We're referring to pages 1 and 2 to the 2 invoices.
Got it.
So, Mr. Haupt, do you recognize these invoices?
Yes, I do.
Are these invoices for this defendant's account?
That is correct.
Did your company prepare these invoices in the ordinary course of business?
Yes, we did.
Was the information contained in these invoices input by someone with knowledge at or near the time of the transactions?
Yes, they were.
And were these invoices kept in the ordinary course of business?
Yes, they were.
Judge, I asked that the 2 invoices, pages 1 and 2, be marked as plaintiff's composite 1 or A, whichever the court prefers.
I would prefer numbers. I know we're not going to exceed 26 exhibits, but
Right.
it's just, but by practice, I always go with numbers. Mr. DeSico, do you have any objection to proposed 1 and 2 being admitted into evidence at this time?
No, sir, I don't.
All right, it'll be admitted as plaintiff's composite 1. And Amanda, what I'm going to do is, I've got the stickers here. I'll mark them and make sure they get delivered to you at the end of the trial. Okay. All right.
Thank you, Judge. So, Mr. Haupt, what are the various goods described on these invoices?
All right. On the one that's labeled 1 at the bottom, we have 4 picture windows. They were the 7720 A's picture windows from PGT. They're impact frame. They were aluminum. They're insulated with low E. And then the 3 mole bars with the clips to mold them together. And item number 2 were the rectangular tubes used to make the frames for that.
Thank you. So, did you have personal communications with Mr. DeSico or the defendant about what goods to order?
That is correct. From day one, I've been working with Mr. DeSico.
Okay. So this product, the PGT windows, was that the first product you two discussed?
No, sir, it was not.
So continue.
The first product we discussed, I recommend using gatewood glass to customize a window that would fit in there, that would seal, and it would be framed unit that was built on site by gatewood glass.
And what happened when you recommended that product?
He asked me about the price of it, and once I told him the price, they said they would go a different route. I gave them the second option, which I said isn't the best option. Obviously, option 1 would have been number 1 option for that.
Okay. So when you moved on to the PGT windows, did you do any sort of research or look into whether that product was appropriate for this application?
Yes, we did. So I've been involved in our window department for 10 years now. I'm very familiar with what they can and cannot do. And I went out on site with Jesse. We looked at it, and I told him, to the best of my knowledge, the PGT brand would work the best for this. We looked into the NOAs and the FL numbers, the product approval numbers, to try and find out, to make sure they would work. It took us about 2 weeks to look into that and make sure that that application would work for this, what they were trying to do for it. I spoke with our PGT sales rep, and he didn't have anything to say no, they would not work. So to the best of my knowledge and the best of his knowledge, they were windows that should be applicable for that job.
I'm sorry to interrupt, but just to fill me in so I have a better picture of what's going on, what was the application specifically that these windows were for? What was the project?
It was for an overhead, not a terrarium, but kind of an overhead windows that would go over the head, over the top. So it was like a sunroom, but instead of having a composite roof, they had windows on top.
In a house?
On the exterior of a house, correct.
Okay. All right, thank you.
Sorry, and I was going to clarify a few things because I know, Judge, you and we don't know anything about this type of stuff. They don't teach us this in law school.
I've never claimed to be a construction expert, no.
So you had mentioned that you reviewed NOAs. What's that?
Those are the notice of products that they need to be state regulated to make sure they pass all impact rating systems and pass codes.
So who's that issued by?
PGT. That's issued by the state of Florida to PGT after testing.
Okay, so you received that from the manufacturer and you reviewed whether this application would be appropriate.
That is correct.
Okay. And again, was there anything that you saw that would show that there was anything inappropriate about this application for this product?
Absolutely not, or else we wouldn't have sold them to them.
Okay. And did you describe this process to Mr. DeSico when you were discussing ordering this product?
Yes, he asked me about the 2x6 rec tubes, and I said those would be the best things to build out a frame. He asked if we had clips or something to put them together, and I said no, brackets to put them together. I told him no, we didn't. They'd have to manufacture their own. I explained to him the best possible way to do it using the 4 different windows and 3 mole bars. At the beginning, our fear was that it could leak, and it eventually did leak.
Okay. And this was all advised to Mr. DeSico?
That is correct.
Okay. So the goods that were ordered, which was the PGT windows and these other associated products, were those the actual products that Majestic, the defendant, received?
Yes, sir, they were.
And to the best of your knowledge, were there any defects with those products?
There were no defects with those. No,
Okay.
sir.
Okay. So now moving on, plaintiff's records, do they contain any documents showing the amounts due from the defendant?
Yes, they do.
And this, I'm referring to page 3, so what's marked page 3 on the bottom. This is the statement. Mr. Haupt, do you recognize this statement?
Yes, I do.
Is this the statement for the defendant's account?
That is.
Did your company prepare this statement in the ordinary course of business?
Yes, sir, we did.
Was the information contained in this statement input by someone with knowledge at or near the time of the transactions?
Yes, it was.
And was this statement kept in the ordinary course of business?
Yes, it was.
Okay, Judge, I asked that the statement be marked as Plaintiff's Exhibit 2.
Any objections, sir?
None.
All right, be admitted as plaintiffs 2.
Thank you, Judge. So can you just briefly explain what we're looking at on the statement?
All right. On the statement, if you look over underneath the town and country heading, you see that Majestic Enterprises is the customer. If you look at the top right where it says statement, their customer number, the 118188, that is their customer number. The date was correct. The amount was correct for the total due, and everything is correct. Yes, sir.
So as reflected on this statement, what is the principal amount due from the defendant?
$6,732.76.
And is that the prices reflected on the statement and invoices? Does that represent the agreed upon sales price or the reasonable value of the goods delivered?
Yes, it does.
And has the defendant paid any monies to reduce the balance?
No, they have not.
Judge, I have no further questions for this witness.
Mr. DeSico, do you have any questions for this gentleman?
No, sir.
All right.
Plaintiff rests.
Mr. Spreckman, did you wish for Mr. Hobbs to remain, or is he released at this time?
Remain, please, just in case.
All right, very good. All right. There were some other, well, you rest at this time, is that correct, sir?
Yes, the only other documents were just a letter, but it's not critical. And then just in case the court was interested, it's the fictitious name record for Town and Country, showing that their actual name is American Builders and Contractors.
Got it. All right. All right, Mr. Seeger, here's your opportunity. The packet was there in the mailbox, so I do have what you sent, sir.
So you do have it?
Yes, sir. I do have it. I'm holding it in my hand now. So go ahead. And if you want to give a brief opening to sort of explain your circumstance, but then again, since you're also sort of testifying, why don't you just, tell me your side of this. Explain to me why you feel that the plaintiff is not entitled to the relief being sought.
Okay, my name is Jesse DeSico. I represent my company, Majestic Enterprises. Mr. Hopp, I've worked with in the past before. He's a gentleman. We've worked together well until we came to this particular situation. There's no doubt we did purchase the product as specified by Mr. Hopp. The product was product that he recommended from his company, Town and Country. There's no argument about what was sold and received. I paid for the product in full the day I ordered it. The invoices were paid, and as far as the material was delivered as purchased. The problem with the material, and I have, if you look in the package that I sent to you and also copied Mr. Spreckman, right from PGT, from the senior code compliance engineer, there is an email there that states that the product is not to be installed at an angle greater than 15 degrees vertical. So the product that Mr. Hopp talked about leaking, he's referring to us building out and adjoining the windows together and them possibly leaking because you've got all these different pieces. That's not what leaked. The day that we installed the windows and completed the installation, the actual product failed because it is not to be installed greater than 15 degrees from vertical per PGT, which is the company that he represents, and he's, promoting their product. So if he said that he took the 2 weeks and he did research and checked the NOAs, I have the email here that is sent to me from PGT, which is the manufacturer of the product, that claims that that's incorrect. How we found this out was the day that we completed the installation. The next morning when we went back and we had the windows that were leaking, I immediately called Marcus, and he had sent someone from PGT out to take a look, and all of the chain of emails and everything is there. They looked at it and said they could not warranty the windows because they were installed out of spec. And that was where the issue began. This was in the middle of a bath remodel that was being redone underneath the glass. So I'm actually still working with Mr. Lewis, who lives in Canada, and correcting this situation. So not only, besides that, I reached out to Town and Country. If you read through the emails, I asked them, what can you do to help me rectify this situation? I've paid for the product. I've installed and built out the product that you've advised me. He came out to the site, saw the situation. There were no surprises. I built out the work, and the product failed. So I was basically left standing in the middle of a job with a great deal more of work to do, with now a window that leaks.
Well, I have a question, and I'm going to sort of deviate from the normal procedure of things. Mr. Spreckman, I'm being told by Mr. DeSico that he paid for the product.
No,
May I
Because that, yes, sir, because that, that is the,
originally
that is the claim in this case, that the product was
Yeah,
not
it
paid
was,
for,
it
right?
was paid and I believe then charged back.
that's correct.
It was
After several months,
So it's
had
not been paid.
Okay, so because that's, obviously an important
Of course.
point.
Of course.
All right, so Mr. Stiga, you agreed that what happened was you paid for it, but then you did a chargeback on your, I assume, a credit card.
yes, sir. That's exactly what happened.
Because of dissatisfaction with the product.
That's correct.
Okay, all right. So as of this time, ABC has not received payment.
That's correct.
The question is whether or not they're entitled to. Okay,
Yes, sir.
got it. All right. So well, let me start with this. You've asked me a couple times to kind of read through this packet. Are there specific documents in here? Because there are quite a number of pages. Are there specific documents you're asking me to accept into evidence at this time, or is it the entirety of the packet?
If you look at page number 8, there's an email exchange there between Mr. Hoff and I, explaining the situation. I'd be happy to read it out loud, or if you want to look at the page. I've also shared these with Mr. Spreckman regarding the issues with the window. There's our email exchange back and forth, several pages of that. There's also email from PGT, which states what I had explained earlier regarding the 15 degrees from vertical. That was the email from the senior code compliance engineer there at PGT, which I spoke directly with. So I don't know, maybe you'll have to look through everything.
All right. Well, Mr. Spreckman, do you have?
Yeah. So, Judge, I'm going to object on 2 grounds. One is hearsay, especially from the PGT rep who's not here, but also that I believe the purpose of this being introduced is, well, and Mr. DeSigo can correct me if I'm wrong, or the court can correct me if I'm wrong. I think the dispute, what this is being used for is, one, to just show that Mr. DeSico made a dispute, but I don't think that has really any relevance to what's going on here. But that was after the fact. And then also what PGT had told Mr. DeSico after he ordered and received the goods. And really the only issue here is whether my client, ABC, had any reason to know that this product may not be appropriate for this application. Mr. Haupt testified thoroughly about how he did a bunch of research, spoke with the manufacturer about how there was no indication that this wouldn't be appropriate. And using an email from after the fact isn't being used to show that ABC had any knowledge of any sort of problem with the application prior to ordering and delivering the goods.
All right.
Sure. May I say something?
Yes, sir.
It makes absolutely no sense. Marcus just stated earlier that he's been representing PGT products at Town and Country for a number of years, and now it's irrelevant that the PGT code compliance engineer sent an email with all of his credentials and everything on there that Marcus put me in touch with. Marcus put me in touch with those PGT reps. So how could it be irrelevant? And the reason why the product was not paid is because it was recommended. These were goods that were recommended by a rep who's a professional in his field. On the backside of this, you have a homeowner who has a leaking window, has a project that's happening that can't be completed because of it, and who's getting upset. And I'm taking the heat on the entire thing and dealing with all of the situations and having to find a remedy. And there were no responses by Town and Country. If you read through the email log, and Mr. Spreckman stating that the emails are irrelevant, that doesn't equate to me.
I'm not sure that they are irrelevant, but the hearsay objection is appropriate in the sense that The legal definition, sir, of hearsay is an out-of-court statement being used to prove the truth of the matter asserted. And so anything that was stated by the PGT rep to you regarding the specs of the windows and whether or not they meet this particular project are out-of-court statements being used to prove what you're trying to say. And so the hearsay objection is sustained.
Okay, so what does that mean?
It means that I can't consider the emailed statements by the PGT rep. You know, if you needed someone from PGT to say, you know, whether or not you know, these windows were appropriate for this application or not, they would have had to testify in this hearing.
Okay, I can understand that. How about reading through the emails from Mr. Hopp, the email exchange?
Mr. Spreckman?
It depends on what portion I suppose he's talking about.
Okay.
Because I mean, I've read through it, and I don't think any of it would go to show that anything wouldn't be owed.
All right. Can you there's several pages of emails exchanges, sir. Can you point me to a specific page?
Well, it's basically a chain of how everything works, where you can see that there was no response as far as dealing with the issue. I asked Marcus, you know, due to the fact that it was not the correct product for the application, which voided the warranty, which makes the product unusable to our customer. I let him know that I would be returning the windows to him, and I would expect a full refund and you know, a way to resolve the problem, because I was not getting any type of response. So he then tells me that he's been out with the flu and he's getting back. He knows that Town and Country is not going to reimburse me, but he's working with PGT still. The warranty will be for the glass and the frames. You know, he was working on pushing that they would still warranty the product. So we just continue going back and forth, and you know, to no avail.
So, may I say something, sir? Or
Your attorney is shaking his head vigorously.
No? Okay, never mind.
All right. All right. As far if you're maintaining a hearsay objection, Mr. Spreckman, that would be overruled because I would consider that a statement by party opponent.
Right.
I also would. Well, let me ask you: Are you objecting to any other grounds?
Yeah, I was objecting under relevance grounds because I don't think the emails between ABC or Mr. Haupt and Mr. DeSico have any bearing on liability or amounts due.
Given that they're specifically discussing whether or not, you know, a refund is appropriate, respectfully, I'm going to overrule the objection at this time. All right. So the packet that I've got at the top, I know you probably can't see it, it's like glazed. It says you know, email exchange with vendor, Mr. DeSico. I'm going to admit that as defendant's composite 1. Okay.
Okay.
Because it's separated off, Mr. Spreckman, from another group that says second email from manufacturer. And that one I'm separating off because that came from PGT. You know,
So this chain of email does include emails from PGT as well.
All right.
But as long as we're only the emails between the two parties is fine.
Yes, sir.
Understood.
So for all intents and purposes, I'm going to effectively redact those portions from any consideration.
Understood.
But it is very small print, so you have to bear with me in just a moment. I will say is there seems to be a recommendation from Mr. Haupt that it can be resolved with with silicone, that that the leaking can, that there was a potential fix to the problem.
That was taken, that was tried by the PGT service technician to no avail.
All right, so a PGT service technician came out to the site,
Warranty technician, yes, sir.
tried to fix the issue, and they were unsuccessful.
Yes, sir. Also, if you see the email dated October 29th, 2019 from Mr. Haupt, he says, AJ, what is going on with this? This is making me and Town and Country look poorly. As I've stated, there is nothing showing that the windows could not be used in the manner that we did. And that was sent to the National Accounts Manager at PGT Windows and Doors.
What's the status of the glass now?
The glass is still in place, and we've contracted with a window company to remove it and then reinstall, and basically at my expense.
Reinstall the same glass.
No, reinstall a new window system.
Okay.
And I have a letter. I received a letter yesterday from my customer because he's out of the country. So I don't know if I'm able to give that to you or if I need to give it to Mr. Spreckman, but he was party to all of this, and I assume that will be considered hearsay also, but it basically states the entire thing. But further, if you look in the email here from AJ Giacone, which is from PGT on October 30th, he tells Marcus right here that, as we discussed, PGT tests its product with a maximum angle of 15 degrees. So if that's stated and it's in an email that went right to Marcus, is that going to be inadmissible as well?
Yes, that portion of this email chain is an admissible hearsay.
Okay.
However, was there anything further, Mr. DeSico, that you wanted to tell me?
No, sir.
All right. Anything further from you, Mr. Spreckman?
Yeah, if I could ask Mr. DeSico some questions.
Sure.
Okay. So, Mr. DeSico, do you have any evidence or facts that would indicate that Mr. Haupt or anyone at ABC or Town and Country would have knew or should have known or reasonably should have known that the windows were not proper for this application prior to delivery of the goods?
My answer is that I relied on his expertise to make a recommendation. As a professional in my industry, if someone comes into my store and they ask me to make a recommendation for a product and I spec that product and it fails, I stand behind the product. I don't stonewall the customer and then not assist them. And I realize that this is a large corporation and Mr. Haupt is an employee and I'm a business owner, so it's a different situation and he can only do so much. But that's my answer.
Isn't it correct that Mr. Haupt did try to assist you in getting PGT, the manufacturer, to cover the warranty that they placed on the goods?
He did communicate with PGT and they came out and they said that the product was not under warranty.
Well, didn't then Mr. in the emails that were introduced into evidence, didn't Mr. Haupt advise that PGT was going to warranty the glass and the frames, just not the work to replace them?
And when the rep came out, he would not do that. They put silicone on the window stopped leaking, and then a day and a half later it started leaking again. And when we called them, we were told that the product was not under warranty because of the application.
Okay, so
go back and speak to Town and Country.
So let me go back to the issue that I was talking about before. So Mr. Haupt testified that he did quite a bit of research into whether this application would be proper and explained to you the research he had done to see if this would reach this application.
The research that he had done was not ever explained to me. This was the product that he specified, and that was the product that we purchased.
Okay. And are you a contractor?
Yes, sir.
Okay. How long have you been a contractor for?
20 years.
Okay. So you would have some expertise in these type of building materials as well, right?
I do, in the building materials, not the product specifications. That was why I involved Mr. Haupt and Town and Country, because they're professionals. They spec windows and doors, they provide products, and I would expect that they would be able to point me in the right direction on which product to use. That was the reason for having Mr. Haupt come out to the site and meet with myself and my customer.
So did you review any of the advisements from PGT, these emails aside, about whether they would give ABC or Town and Country any sort of indication that this wouldn't be a proper application?
I did not know.
Okay.
I've installed many PGT products and I use them for all of my window and door installations. I'm familiar with the product. It's a superior product. It's got superior impact resistance. The factory is here in Southwest Florida, so I'm familiar generally with the product as far as its quality, and that was why we wanted to go with the PGT product.
So you're familiar with reviewing the specs of products that you order?
Not reviewing the specs as far as the application. That was why I involved Mr. Haupt.
Okay, and did ABC or Town and Country or Mr. Haupt ever expressly guarantee that this would, that they would guarantee this product would specifically work for this application? Or did he tell you that?
Out and specified that this was the product, I took that as his guarantee that this was the product to use for this application.
But did he guarantee it?
Personally?
Yes.
No.
Okay. I have no further questions, Judge.
All right. All right, anything further?
I have some argument, but.
All right, Mr. Seeker, anything else you wanted me to consider? All right. All right. Yes, sir, Mr. Speckman, go ahead.
Thank you, Judge. So I don't think there's any dispute that this is a good that was ordered, delivered, and accepted. I can go through the statutes that provide that to the court, but it was clearly accepted. Mr. DeSico or his company had ample opportunity to inspect the goods. I don't think there was any defect with the goods. It was exactly what was ordered. And they took an act inconsistent with rejection by, in fact, installing the windows. So other than that, I suppose what Mr. DeSico is getting at is that there's some sort of implied warranty or something that would come from ABC. But there's a few reasons why that wouldn't apply here. One is that there's been no evidence that there's any reason that ABC would have had, or Mr. Haupt or Town and Country would have had any reason to know that this would not apply to this, that would not work for this application. They did, as was testified by Mr. Haupt, he did his due diligence, explained it to Mr. DeSico, and they did everything they were supposed to do. There was no express warranty provided, and there's no testimony that there was such an express warranty. Additionally, you know, on a more technical matter, there's really been no evidence about why this product failed. That would require either someone from PGT or an expert to show why this product failed, and there's no necessarily a link between why the product failed and anything that was done from ABC. Finally, for the implied warranty, there needs to be a reliance, a reasonable reliance on what was provided by the seller. In this case, the seller, which was ABC, did all the research they were supposed to do. Mr. Haupt explained it to the customer in this case. Additionally, the customer, which is the defendant in this case, has sufficient expertise to not have to rely on this seller. Now, if I, as a lawyer who has no idea about anything, would go to a manufacturer, I would suppose that would be more likely for this implied warranty to come into effect. But not only is Mr. DeSico of a higher standard for this type of product, but as I stated, Mr. Haupt testified that he explained thoroughly to him the process that he took to determine whether this would be a proper application, and all the research that he did indicate that this would be a proper application. This is really a dispute between Mr. DeSico and the manufacturer. What, you know, when was testified to, Mr. Haupt did assist in trying to get the manufacturer to cover the warranty. As far as Mr. Haupt knows, and you could see in the emails that were admitted into evidence, the manufacturer, PGT, was going to warranty this product and was going to replace it. They just weren't going to cover the labor. There's been no one from PGT to say that they aren't going to cover the warranty in any reason, and if they weren't going to cover the warranty, any reason why they weren't going to cover the warranty. And I mean, we've kind of went through this about the hearsay before, but any communication from PGT about if or whether they were going to or why they were or were not going to cover the warranty would have been hearsay. But they're not here for me to cross-examine them about why they are or are not warranting the product. So if there's some disability with the product, that's really a dispute between the defendant and the manufacturer, PGT, about this warranty that's in place. So in conclusion, there's really nothing that would implicate ABC, Town & Country, or Mr. Haupt into guaranteeing this good explicitly, implicitly, or anything like that. It's not their good, they're just a seller. There's an actual warranty from the manufacturer, and that's where this dispute should run between the purchaser and the manufacturer.
Give me just a moment, please.
Absolutely.
All right. Mr. DeSico, did you want to say something? Sir, I can't hear you.
I don't have much more to say. I think we've covered everything, and it doesn't make too much sense to me that, direct correspondence can't be submitted as evidence, but I'm not in the law field. I probably should have obtained an attorney, but I did not, because, the truth is right here in front of us. I guess we'll just have to hope for the best outcome and see what happens. I ask you to consider the fact that I'm still having to pay for a new product, and I've stuck behind my word to my customer and made good on my work, as Town and Country and ABC should learn how to do.
All right. I think, Mr. Beckman, I think you kind of hit the nail on the head of the two primary issues for the court to consider. Is one, the technical matter of whether or not it's been established that the product that was sold was in fact effective to the point that would entitle Mr. DeSico to refuse payment for the violation of, since there was no express warranty, potentially an implied warranty. And the question is whether or not there was an implied warranty, the suitability of this product for this application. This is going to frustrate all of you. What I'd like to do is I want to spend a little bit of time researching case law on the issue of implied warranty. I'm not, frankly, knowledgeable enough on that particular subject to make a decision at this time. I'd like to do a little bit of research on that to see if that particular body of law would apply under the circumstances. And even if it is, I have to really consider whether or not there was sufficient evidence to establish that it is in fact the seller's responsibility under the circumstances to ensure the applicability of the product for the application.
And Judge, if I could just to direct you on your research.
Yes.
Is statute 672.714.
Say it again. 672.
672.714.
All right.
And
is a Florida statute addressing implied warranties?
Yes. What I just want to direct the court to when you're doing your research is paragraph 2, which is if the court were to, while of course I disagree that the implied warranty would come into effect.
Right.
It's the remedy. If the court were to find it came into effect, the remedy is not finding no money due, but it's the difference between the value of the good accepted and the value of the goods if they were as warranted.
I understand.
So I just want to point that to the court.
Mr. DeSico, put all this in plain language. Since there was no explicit contractual warranty or guarantee from the seller in this case, they didn't put in writing, if these windows don't meet your needs, you will refund the money. The only way, legally you could be entitled to any sort of recourse would be if the court couldn't find that there was some other legal basis for you to refuse payment. The one possibility, and like I said, I have to confess my own lack of sufficient knowledge in the area, which is why I'm going to research it, would be this notion of an implied warranty. I don't know if that's necessarily going to apply under the circumstances. And generally speaking, this is sort of happening backwards, legally speaking, in the sense that normally there would be, Mr. C, you would find yourself in the plaintiff's seat, after having paid for a product that was otherwise insufficient, that you could, seek compensation from the party that sold you or otherwise delivered to you the damaged, improper, or otherwise defective product, which also kind of complicates the analysis.
Sure.
Does that make sense?
Yes, sir.
All right, so what I'm going to do is I'm going to reserve at this time. I will try to get a ruling before the end of the day. Let me just take a quick look at this area of law, familiarize myself a little bit more with it before I make a decision, okay?
Yes, sir.
But I appreciate all of your time today.
Thank
Thank you, Judge. And if there's anything you need from us, just let me know.
All right, thank you very much. Amanda, I'm going to mark those exhibits and have them ready for you to pick up at any time, okay?
Good,
All right, thank you, everybody. Have a good day.